Estate planning can be complicated and confusing, whether you do it yourself or even if you do it with an attorney. The laws are constantly changing and they're complicated. Plus, you add to that, there are a lot of emotions that go into who you are appointing and who is going to get what in your estate, and those can cause havoc on your estate planning. So we know how to ask the right questions and to come up with the right solutions for our clients. As part of this, we've created a checklist of things that clients don't consider that I want to go over with you here. One is, do you have children that are over 18? They're still your kids, but did you know that you don't have any ability to help them out without having a durable power of attorney, a financial one? And for medical needs, a medical power of attorney. Did you know that if you're living with a significant other and you're not married, that if something happens to you upon your death, that significant other may receive nothing from your estate unless you provide for it in your estate planning? Many families endure the challenge of mental illness in their family. I see that quite frequently, although clients may not want to admit that they have that in their family. Were you aware that you have no ability to help out these family members without having a financial power of attorney and a healthcare power of attorney? In particular, you want in those powers of attorney something that is going to cover the Mental Illness Act so that you will be able to have access to the paperwork necessary to have you help them move forward with treatment. Some people believe if they have a will, that means that their estate is not going to be probated. But did you know that a will is just your instruction manual in probate? In addition, if you have done some estate planning and you have a will and a trust, sometimes you have to probate your estate anyway because you didn't transfer your assets into trust. In addition, if you have no will at all, which many people come to me and they say, well, why do I care? I'm dead anyway. If your assets are over $100,000, you can't even use a small estate affidavit, so you will have a probate in many events that most people don't consider. Check your beneficiary designations on your life insurance, on your IRAs, on all things that have beneficiaries. This is important to make everything flow the way you want to upon your death. If you are recently divorced, it's even more important for you to change your beneficiaries and check them out. Most of the time, spouses are on there as beneficiaries of life insurance and 401ks and what have you. When you get divorced, your divorce agreement says that it's all going to flow to one side or the other. This does not change your beneficiary designation for you. If you die and that ex-spouse is still on as a beneficiary, that ex-spouse may end up getting that property. If you have a spouse from a second marriage and you have children from a first marriage, sometimes the central asset in the estate is a business. So if you die and you don't do anything with your estate planning, your second spouse may end up owning the business along with your first children. I'm sure that's not the result you had in mind. If you are considering making a gift to charity and you have substantial 401k or IRA assets, consider listing the charity or charities as beneficiaries of your 401k or your IRA in order to save taxes. It will go directly to that charity upon your death, and there will be no taxes, income taxes, that have to be paid as a result of that transfer. If your family is immersed in conflict, or you think that a spouse of one of your children might be causing problems upon your death, consider using a bank trustee as the trustee and executor of your estate planning documents so that you can limit the amount of potential fighting that's going on. You are also dealing with a professional advisor, a professional trustee who is used to seeing these type of things happen and knows how to diffuse these things going forward. Remember, your estate planning needs more than a will. It may need a trust, it may need powers of attorney. And in order to have things go to your family the way you want them to, you need to provide that in your documents and make sure that your property is properly transferred into a trust name if you're using a trust. Every 5 years or so, you need to look at your documents. People move away, things change, and you may want to change documents to reflect that. It's important for you to do, or you will have unintended consequences at the other end if you die. We are here to help, so please reach out. We are happy to help you with these important matters.